Hi everyone, thank you for joining Seacrest Wardle's My PIP Monthly, September 2019 edition. My name is Javon David, a partner in Seacrest Wardle's Troy location. This month's podcast is actually August 2019's podcast. We had some technical difficulties that did not allow us to launch or premiere the podcast last month. So those of you that signed up for the August 2019 podcast will find the content to be the same for this month. For August 2019, we've got a couple cases that we believe are noteworthy and worth a discussion beyond the traditional newsletter. One is a published decision, George versus Allstate, which was issued earlier this month, and the other is Newby versus American Zurich Insurance Company. As for the trending topics in PIP litigation, I'll be going through first-party benefits, an overview of survivor's loss benefits. Last month, we did have a case that discussed survivor's loss benefits. And after that episode, we got several questions from people that are listening about what survivor's loss benefits entails, and we thought it would be a good idea to provide an overview of survivor's loss benefits to serve as either a refresher course for those of you that already have it and understand it, and also just to kind of keep up with what's available to individuals making the claim for survivor's loss benefits. Now, the first case in the case law update is George versus Allstate, which is a published decision, which means that it's binding law. In George versus Allstate, the court reviewed an ERISA plan containing an unambiguous coordination of benefits clause and found that it controls over state law. So in the George case, the plaintiff was injured in a motor vehicle accident but did not have a policy of no-fault insurance available. As a result, the plaintiff filed her claim through the Michigan Assigned Claims Plan, who then assigned her claim to Allstate Insurance Company. At the time of the accident, plaintiff did have health insurance and disability insurance for wage loss through a self-funded plan organized under ERISA, which also stands for Employment Retirement Income Security Act, and was ultimately administered through Aetna Life Insurance. So even though the plaintiff was seeking benefits through Allstate under the assigned claims plan, she did have health insurance available to her. There was language in the ERISA plan that stated as follows. It had a non-duplication of benefits clause, and it states, if you and your spouse or domestic partner both work, your family may be covered by more than one group health plan. The plan coordinates its payments with the payments you may receive from other group insurance plans under which you or your dependents are covered. The following types of plans are coordinated with your plan coverage. And in that subsection, it stated motor vehicle insurance, your own or other responsible parties' insurance. The other plan is automatically primary if it does not have a coordination of benefits provision, it's a program provided by law, or it's a motor vehicle insurance policy. Based on this particular language of the health insurance clause, Allstate moved for partial summary disposition, asserting that because the ERISA plan was a benefit source that covered the same loss, it was entitled to a set-off under MCL 500.3172, which is the assigned claims statutory provision of the No-Fault Act. Under that section, it states that personal protection insurance benefits payable through the assigned claims plan shall be reduced to the extent benefits covering the same loss are available from other sources. The trial court determined that because plaintiff's benefits were only available through the assigned claims plan, MCL 500.3172 was not preempted by ERISA. The trial court granted partial summary disposition in favor of Allstate, ruling that Allstate was secondary to the ERISA plan for medical expenses and wage loss benefits. Now, oftentimes we do see the ERISA arguments coming into play when you're arguing about whether or not the insurance policy itself versus the ERISA plan is going to be primary or secondary. But here, it's a little bit of an unusual fact scenario because it's an assigned claims carrier making this argument. As we all know, the assigned claims carrier does not have its insurance policy. There is no policy, so there's no language to look to determine whether or not there is, an ability to say that you're secondary to a different plan. So you have to look to the statute itself. So on appeal, the Court of Appeals was tasked with determining whether federal law preempts state law as it relates to the coordination of benefits of an ERISA plan and an assigned claims carrier under MCL 500.3172. After a review of the case law, Michigan Court of Appeals determined that for a state law pertaining to the coordination of benefits to be preempted, the ERISA plan must be self-funded and contain an unambiguous coordination of benefits clause. The court further found that the case law that Allstate relied on was heavily distinguishable. Ultimately, the court held that the plaintiff's ERISA plan is self-funded, and it contained an unambiguous coordination of benefits clause. Therefore, Allstate is primarily liable for the benefits at issue. And if they held anyway otherwise, they would be saying that the state law trumps federal law, which is simply not permitted under the case law. And the Court of Appeals explicitly stated, to hold the contrary would have the direct effect of dictating the terms of the ERISA plan, which the state is not permitted to do under federal case law. Now, this case is important for those of you handling MACP claims on behalf of an insurance carrier or on behalf of the MACP directly before it's assigned out. You're going to want to understand what the plan that you're disputing states, but you're going to want to keep this particular case law in mind and understand that generally preemption does apply and the ERISA plan would not be primary for first-party benefits. Now, the next case that came down this month is Newby versus American Zurich Insurance Company. This is a particularly interesting case because, especially for those of you handling claims in the litigation phase, we often do run into the issue as to whether or not we're able to have ex parte communications with plaintiffs' treating physicians. Now, what that means is that instead of taking the deposition of the plaintiff's treating provider, that you can just call up or set up a meeting with the provider directly and talk about something that is of relevance to the claim. Oftentimes in traumatic brain injury cases, for example, you want to know more than what's just contained in the records. And quite frankly, that can be done by just having a conference with the physician instead of going through a whole deposition, formal discovery process to answer your questions about the very specific details of someone's brain injury or someone's just injury in general. So I'm sure you've worked with your counsel to say, hey, maybe the plaintiff attorney or maybe the plaintiff will allow us to have ex parte communications with their physicians. But they have to consent to that. And they have to say that you're able to do that without them being present or without them taking a deposition. And if they don't agree to it, then you have to file a motion with the court and generally prove that there's some good cause for you having these ex parte communications with the individual's provider. So that's essentially what went on in this case. So just for factual background, the plaintiff was involved in a motor vehicle accident and was insured with Zurich. Ultimately, she filed suit against Zurich, stating that they improperly withheld her PIP benefits. After she filed suit, the defendant sought ex parte communications with her treating physician, and they argued that she waived her medical privilege by filing her lawsuit. So the argument to the court was that because she filed a lawsuit, she placed her medical condition in controversy, and we have a right to therefore investigate her medical condition by talking to her ex parte physicians. The plaintiff attorney and the plaintiff did not allow the defendants to speak to the physicians and waive that privilege, essentially. So defendant ultimately had to file a motion for protective order on the issue because the plaintiff failed to sign a stipulation and order regarding the ex parte communications. Ultimately, the trial court denied the motion that argued that the plaintiff waived her physician-client privilege when she filed the action for PIP benefits. They also denied the motion for reconsideration, which ultimately led to the appeal. On appeal, the defendant argued that ex parte communications with plaintiff's physicians should be allowed, and it's allowed in other forms of civil litigation such as medical malpractice. Ultimately, the court did a very in-depth analysis of a medical malpractice case that allowed ex parte interviews with the plaintiff's physicians, but only after the plaintiff waived the physician-patient privilege. The Court of Appeals noted that that was the key difference in the cases that the defendant relied on versus the cases that was before the court. The plaintiff specifically said that the defendant cannot engage in ex parte communications with treating physicians. Now, ultimately, The Court of Appeals also noted that there was nothing unusual about the plaintiff's particular case here that would warrant those ex parte communications. She was not attempting to conceal any kind of medical treatment, for example. And the court noted that the information that was sought by the plaintiff or by the defendants could have been easily obtained by taking the deposition or by engaging in other written forms of discovery. So while this was, I guess a creative attempt to try to get at the ex parte communications, the Court of Appeals was working to clarify what you can and can't do if someone doesn't waive their privilege. And ultimately, it provides those protections to the plaintiff that they are not going to be waiving medical privilege just because they file a first party lawsuit. So in those kinds of cases, you can work with your counsel, see if the plaintiff attorney is going to allow you to speak to the treating physicians without them present, or if you'll have to go and file a motion for protective order on the issue. Now, in our experience, just generally, the courts don't like to allow this ex parte communication, and they'll do what the Court of Appeals did here, which was say, go take the deposition, go file, additional request for admissions, or go send them interrogatories. There are other avenues that you can get the information you're seeking without having those ex parte communications without the plaintiff present. Now, this month in Trending Topics in PIP Litigation, we will discuss survivor's loss benefits and provide an overview of what that entails. So under the No Fault Act, what are survivor's loss benefits? The survivor's loss benefits are governed by MCL 500.3108, and they set forth the provisions for benefits to the surviving dependents of a fatally injured person. So if someone dies in an accident, their family members, spouses, children, parents are able to potentially collect on their survivor's loss benefits statute. The benefits under this provision include financial support that the dependents would have received from the deceased, plus up to $20 per day for replacement services. Now, generally speaking, dependents can include a spouse, children, or parents, but there are exceptions to every rule. For example, a spouse is no longer eligible to survivor's loss benefits if they remarry. They lose that right to collect survivor's loss benefits once he or she marries. In addition, parents are excluded as dependents unless the parents can be considered persons physically or mentally incapacitated from earning, and the statute specifically talks about whether or not the individual is entitled to benefits, and you can do an analysis by determining whether or not they're physically or mentally incapacitated. So generally speaking, the children are the individuals who benefit the most from survivor's loss benefits, but there are other people who can qualify, such as the spouse or the parents. Now, what do survivor's loss benefits entail? Survivor's loss benefits include the financial support that the dependents would have received from the deceased, plus $20 per day for replacement services. So the formula that you can always just kind of keep handy or remember is it's economic loss plus replacement services equals survivor's loss benefits. Now, you also have to remember that there are set-offs that reduce that final amount of survivor's loss benefits. In addition, survivor's loss benefits are recoverable for no more than 3 years after the individual passes. They're also capped, just like other things in no fault are capped, like the statutory wage loss claims and things along those lines, household service claims. And the survivor's loss benefits are capped for 3 years, and the current cap is $5,700 per month. Generally speaking, benefits covered under survivor's loss includes income, even though the individual does not necessarily need to be employed at death. So if the person is unemployed at the time that they passed, all that their family members have to show is that they were looking to become employed or that they had some sort of employment lined up. Some case law out there actually suggests that the individual just needs to be able to return to work and not necessarily even have a job offer in order for the income to count as a claim for the survivor's loss benefits. In addition, hospital and medical insurance premiums are compensable, disability coverage, pensions, investment income, annuity income, all of those things are compensable under survivor's loss benefits. It's essentially to make the family members of the decedent maintain the life that they had to an extent as though the person was still alive. I do want to talk a little bit about the job offer issue, because we get a lot of questions about that, whether or not someone is entitled to survivor's loss benefits despite not having a job. And there is case law that supports that position. For example, there's a case called Gobler versus Auto Owners Insurance, which is an older case, but it still stands. The Supreme Court in Gobler allowed the widowed claimant of a decedent to recover survivor's loss benefits even though her deceased husband was not employed at the time of the accident. When he died, he was an unemployed student who had just completed his degree in forestry. Before he died, he applied for a job with the U.S. Forestry Service. 6 months after his death, the U.S. Forestry Service sent the decedent a letter inquiring about his availability for employment. Evidence was offered showing that the decedent was only one of 6 individuals who received the inquiry letter, and that 3 positions were available. That only one of the 6 people who received inquiry letters accepted the job, and that if the decedent had responded, he probably would have been offered the job. That was enough to invoke survivor's loss benefits for lost wages for the decedent. Now, there are a couple other cases that also hold that having an actual job at the time of the death isn't necessary for survivor's loss benefits income. And just be aware that it's possible for someone to make that claim. So don't necessarily deny the claim just because the person doesn't have a job at the time of death. You'll want to investigate what exactly they were, what's their background, did they have a college degree, did they have pending employment? Were they applying to places? And then understand the entirety of the claim before you make any kind of decision. Now, there are set-offs for survivor's loss benefits. Benefits may be reduced by other available benefits such as federal workers' compensation benefits, military benefits, or Social Security benefits. And the case of Wood versus Auto Owners went through the set-off provision of the Act and ultimately creates a formula for reducing the total benefits by the amount of set-offs. So you have to calculate the economic loss plus the replacement services for up to 3 years, and then you reduce the total benefit amount by the set-offs that you may or may not be entitled to, depending on what the person was receiving at the time of their death. If you have any additional questions about survivor's loss benefits, please feel free to contact me. Again, this is Javon David, a partner in Seacrest Wardle's Troy location, and we appreciate you tuning in to our monthly podcast. Thank you.